Well, carrying on from Jean Monnet, that great European, I know that he worked closely with both the British and the Americans during the Second World War, and that Winston Churchill shared some of his enthusiasm for unity between the democracies in Europe. On the 5th of March, 1946, Churchill delivered his famous Sinews of Peace speech in Fulton, Missouri. He memorably declared that from Stettin in the Baltic to Trieste in the Adriatic, an iron curtain has descended across the continent of Europe. His solution was that the safety of the world requires a new unity in Europe from which no nation should be permanently outcast. And later that year, he threw his considerable weight, yes, he did have a considerable weight, yeah, behind the idea of a Council of Europe, which came to pass in the Treaty of London in 1949. And in the following year, the Council adopted the European Convention on Human Rights, in which another British Conservative politician, Sir David Maxwell Fyfe, played a considerable part. I mention this because many of today's British Conservative politicians have either forgotten the original enthusiasm of revered figures such as Winston Churchill and David Maxwell Fyfe, or have concluded that the project has not turned out as they originally envisaged. The preamble to the Convention reaffirms the Council's profound belief in those fundamental freedoms which are the foundation of justice and peace in the world and are best maintained, on the one hand, by an effective political democracy, and on the other, by a common understanding and observance of the human rights on which they depend. But this is debatable. Professor Conor Gearty of the London School of Economics has pointed out that there could be an inherent tension between the human rights project and political democracy. To many, democracy means that the will of the majority, as expressed through their democratically elected representatives, must prevail. The human rights project means that there are certain rights which are protected against violation, even if the majority wills it. My own view, expressed in a judgment in the House of Lords, is that, quote, democracy values each person equally, even if the majority do not, end quote. And this must mean that each person has certain fundamental rights, even if the majority do not like it. Or, dare I say it, even if the elected government of the day finds it inconvenient, as they so frequently do. So despite its early enthusiasm for the Convention, the United Kingdom soon began to find the decisions of the European Court of Human Rights inconvenient. One of the earliest cases against the United Kingdom was brought by Ireland in 1971. Ireland complained, among other things, that the 5 techniques used by the British in interrogations in Northern Ireland violated the Article 3 prohibition of torture and inhuman or degrading treatment or punishment. And in 1978, the court held that the techniques did not amount to torture, but they did amount to inhuman or degrading treatment. The British judge, of course, dissented. He was quite famous for dissenting, actually, but there we go. It was his, quote, emphatic opinion that if a commendable zeal for the observance and implementation of the Convention is allowed to drive out common sense, then the whole system will end by being discredited. And his particular concern was enlarging the terms of the Convention so as to include concepts and notions that lie outside their just and normal scope. This is a complaint which is frequently heard in the United Kingdom today. Though I do have to say that one person's common sense is another person's complete idiocy. I put that in a judgment once, which much to my... But of course, the target then, and now, is the notion established first in the case of Tyra against the United Kingdom that the Convention is a living instrument which must develop to keep pace with changing social attitudes and conditions. But this should have been nothing new to UK eyes. As long ago as 1929, in a famous case called Edwards and the Attorney General of Canada, the Judicial Committee of the Privy Council, which was then the final court of appeal for the whole of the British Empire, had held that the British North America Act of 1867 had, quote, planted in Canada a living tree capable of growth and expansion within its natural limits, end quote. And their lordships did not wish to cut down its provisions by a narrow and technical construction, but rather to give it a large and liberal interpretation. Hence, they decided that while the word persons might not have included women in 1867, probably not, but by 1929 it did. And the same large and liberal approach was adopted in 1980 in a case from Bermuda, where the Judicial Committee held that the word child in the Constitution of Bermuda included a child born to unmarried parents, although it would not have done so if contained in an ordinary Act of Parliament. But as the committee said, a constitution was different. Its interpretation should be guided by the principle of giving full recognition and effect to those fundamental rights and freedoms with a statement of which the Constitution commences. So this was a firm rejection of the American doctrine of originalism, that the text must be read either in accordance with the original intention of the drafters or as the original readers would have understood it. So the UK should not have been surprised or dismayed when the European Court of Human Rights adopted a similar approach to the one that they had adopted to constitutional interpretation. But I think that the British drafters of the European Convention had fondly assumed that the rights it contained were already part of UK law. So it came as quite a shock when the United Kingdom began to lose cases in Strasbourg, quite soon after it had accepted the right of individuals, as well as member states, to petition the court. So to take just a few examples from a very long list, the right to a fair trial in Article 6 implied the right to go to court in the first place, even for prisoners. Judicially ordered corporal punishment of juveniles violated the prohibition of torture and inhuman or degrading treatment or punishment in Article 3. Prohibiting publication of articles about the thalidomide scandal because of the risk of prejudicing court proceedings violated the protection of freedom of speech in Article 10. The continued criminalisation of homosexual acts between adult men in Northern Ireland violated the right to respect for private life in Article 8, and so on, and so on, and so on. So these cases showed that UK law was not always able to protect the Convention rights, and that the UK judges were not always able to do so either. Now, the UK has a dualist system. Treaties create obligations between states in international law, but they do not change the domestic law unless and until Parliament incorporates them. And the rights contained in the Convention had not been converted into rights contained in UK law. So calls to do this began even before these shocking cases, and they came from all sides of political opinion. There was a tract from the left-wing Fabian Society in 1968. There was a lecture series by Sir Leslie Scarman, a distinguished judge, in 1974. And between 1969 and 1997, there were no less than 11 bills introduced in the House of Lords. And in 1987, there was even a private member's bill introduced in the House of Commons, none of which actually got to the statute book. And in 1996, the newly appointed Lord Chief Justice, Lord Bingham, later to become the senior law lord, used his maiden speech in the House of Lords to argue for incorporation. So it then became Labour Party policy. A consultation paper published in December 1996 argued that because their rights were not protected in the UK courts, British people had to undergo the lengthy and costly process of applying to the Strasbourg court. British judges were denied the opportunity of building a body of case law, which was properly sensitive to British legal and constitutional traditions. The European Court of Human Rights had not been able to benefit from the experience of the UK legal system and was neither sufficiently familiar with or sensitive to British legal and constitutional traditions. I do see a bit of imperialism in those arguments, but there we go. They were there for a political purpose. So Labour won the general election in May 1997, and I was privileged to be one of the judges who were invited to sit on the woolsack in the House of Lords to hear the Queen's speech. You could feel the excitement that ran round that woolsack when Her Majesty announced that a bill will be introduced to incorporate in United Kingdom law the main provisions of the European Convention on Human Rights. Ooh, new toys to play with, I think is what it really boiled down to. The bill was introduced in December, along with a white paper. And this explained that it had been thought, when we ratified the Convention, that the Convention rights and freedoms were already protected in British law. But it turned out that they were not. The rights originally developed with major help from the UK government were no longer seen as British rights, which they actually were. The fact that UK judges didn't deal in the same concepts as the European Court of Human Rights limited the extent to which their judgments could be drawn upon and followed. With incorporation, we would be speaking the same language. And that is indeed what has happened. The White Paper considered whether the UK court should be given power to strike down or ignore provisions in acts of the UK Parliament which were incompatible with the Convention rights. The government decided not to do this. Allowing the courts to strike down provisions in acts of the UK Parliament would be likely on occasions to draw the judges into serious conflict with Parliament. The judges did not want this, and the government had no mandate for such a change. Instead, the High Court and above would be given the power to make a declaration of incompatibility, which wouldn't affect the validity of the provision, but would leave it to Parliament to decide whether and how to correct it. Well, it was, and it still is, quite right that the UK judges did not want the strike-down power. But it was perhaps naive to think that politicians and the public could distinguish between a conflict with Parliament and a conflict with the government. That is still the case. So, the Human Rights Act 1998 converted the Convention rights into rights in UK law and gave remedies to victims of actions of public authorities which were incompatible with their rights. This meant that the courts now had to ask themselves whether a Convention right had actually been violated, although we recognised that we should respect certain policy judgments made by Parliament and government. The courts also had a new principle of statutory interpretation, a duty to read and give effect to legislation, so far as possible, in a way which was compatible with the Convention rights. And in Gaidan and Godin Mendoza, for example, the law lords decided that the words living with the deceased as his or her wife or husband could include a same-sex partner. It soon emerged that the government preferred the courts to solve the incompatibility through interpretation, rather than leave it to them to face the political flak after a declaration of incompatibility. So what the government always used to say when they came to us with something, they'd say, oh, it's compatible. But when they lost that argument, as they often did, they said, right, well, you can solve it for us, please. Yeah. People forget that. So there haven't been many declarations of incompatibility, and the government's record of acting upon them has been impressive, although sometimes they have done so through gritted teeth. There is a famous example of one Prime Minister promoting the order to put right an incompatibility while saying that he questioned the sanity of the Supreme Court in deciding that it was incompatible. So there we go. That's how things are. The only example of prolonged resistance has been the blanket ban on sentenced prisoners voting, where the government held out for so long that the Council of Europe eventually gave in and accepted that some minor administrative changes would suffice. But after the Conservative-led coalition came to power in 2010, criticism of both the Strasbourg and the UK courts began to mount. Some of this came from the media. There was no common law right to privacy. our newspapers had got used to publishing all sorts of scurrilous or intrusive private information about celebrities or about ordinary people. But under the Act, the courts are public authorities and have to act compatibly with the Convention rights, even in cases between private persons. So they began to develop a tort of misuse of private information, balancing a newspaper's right to freedom of expression against an individual's right to respect for her private life. And it's a delight to have with us today the principal judge in charge of cases about the word, Sir Michael Tugendhat, who was a prime mover in the development of that tort. So it's great to have you with us, Michael, and congratulations. But of course, that did mean that the media were very unhappy with all of this, and they began to talk about the hated Human Rights Act. Hated by whom? I think hated by the media. But they weren't quite alone. For example, in a lecture in 2011, for example, Jonathan Sumption, Queen's Counsel, soon to become a Justice of the Supreme Court of the United Kingdom, attacked the Strasbourg Court for its detailed development of the general principles in the Convention, for deciding not only whether the member states had proper institutional safeguards for those rights, but also whether it agreed with the findings of those institutions, and for attempting to apply the rights in a uniform manner throughout the 47 member states, despite the fact that the consensus necessary to support it at this level of detail does not exist. He's carried on that attack since ceasing to be a justice of the Supreme Court of the United Kingdom, but he didn't do it while he was a justice. So fixing the Human Rights Act became a recurring theme of Conservative Party manifestos. The 2010 manifesto announced that to protect our freedoms from state encroachment and encourage greater social responsibility, we will replace the Human Rights Act with a UK Bill of Rights. Well, having seen what that was going to mean, I'm not sure that it was going to protect our freedoms from state encroachment, but there we go. From 2010 until 2015, the Conservatives were in coalition with the Liberal Democrats, and so this didn't happen. In 2015, when they were rather surprised to win the election, they promised to scrap the Human Rights Act and curtail the role of the European Court of Human Rights so that foreign criminals can be more easily deported from Britain. So a more radical proposal, but for a more limited purpose. Then Theresa May's 2017 manifesto declared that we will not repeal or replace the Human Rights Act while the process of Brexit is underway, but we will consider our human rights legal framework when the process of leaving the European Union concludes. We will remain signatories to the European Convention on Human Rights for the duration of the next Parliament. Understandably, most of Boris Johnson's 2019 manifesto was devoted to getting Brexit done. But the promise was to update the Human Rights Act and administrative law to ensure that there is a proper balance between the rights of individuals, our vital national security, and effective government. So the plan was to set up a Constitution, Democracy and Rights Commission in their first year. That didn't happen. But the government did set up an independent Human Rights Act review under Sir Peter Gross, a retired Court of Appeal judge, to look at relationships between the UK courts and the Strasbourg Court and between the various branches of government in the UK. This did a huge amount of work, lots of consultation, lots of going around the country, meeting people and so on. And after all of this research, produced a massive report concluding that nothing much was wrong. The House of Commons and House of Lords Joint Committee on Human Rights produced a report, which noted that the Human Rights Act had had a wide impact outside the courtroom, Whitehall and Westminster. The duty of public authorities to act compatibly with the Convention rights had embedded human rights amongst public authorities and reduced the need for litigation to enforce them. The government promptly ignored most of this careful work and published proposals to replace the Human Rights Act with a modern Bill of Rights. On the plus side, the government declared that it was still committed to remaining a party to the Convention, to retaining all the substantive rights protected under the Human Rights Act, and to fulfilling its international obligations. These, of course, include the duty to provide an effective domestic remedy for violations, the right of individuals to go to the Strasbourg court, and the duty to abide by Strasbourg's decisions. But the detailed proposals contained in that consultation paper would have seriously curtailed the protection of human rights in the United Kingdom. And despite a generally negative response to their proposals, the government went ahead and introduced the Bill of Rights Bill. Just to sketch out what that contained, the duty to take account of Strasbourg jurisprudence was to be repealed. The duty to read and give effect to legislation compatibly with the Convention rights was to be repealed. The courts were to be told that they should pay particular attention to the text of the Convention and could look at the travaux préparatoires, an obvious nudge towards American-style originalism, which Strasbourg had rejected long ago. The courts would only be able to develop the Convention rights further than Strasbourg if they had no reasonable doubt that that was what Strasbourg would do. There were to be no new positive obligations. That's an obligation on a public authority to do something. And actually, most Convention rights do involve an element of positive obligation. Worse still, the courts would be given a discretion whether or not to apply even those positive obligations which were already established. And people alleging breaches of their fundamental rights would have to get permission to bring a claim, although people alleging breaches of their ordinary rights don't. All in all, the bill was likely to mean that more claimants would be denied an effective remedy in the UK, more would have to go to Strasbourg, and the UK would lose more cases there. So, the bill had its first reading in the House of Commons on the 22nd of June, 2022. But there was no enthusiasm for it after its promoter, Dominic Raab, resigned as Lord Chancellor in April 2023, and it was withdrawn on the 23rd of June. So, do we breathe a sigh of relief that the bill has been abandoned? I fear not. The government may have drawn back from wholesale replacement, but it has shown itself willing to promote legislation in particular contexts, which means that individuals cannot bring human rights claims in the UK courts and requires ministers and officials to ignore human rights when making their decisions. The Illegal Migration Act 2023 has already done this in relation to the deportation and detention of people arriving in the UK without the permission they need, as most refugees do. The Safety of Rwanda, open brackets, asylum and immigration, close brackets, bill, is seeking to do this in relation to decisions to remove people to Rwanda, as well as requiring officials, courts and tribunals to presume that Rwanda is a safe country irrespective of any evidence to the contrary. Now, the bill has been heavily amended in the House of Lords. I have to confess that I played some part in some of those amendments and was so bold as to vote for them. But the Commons will probably reject our amendments, and it will come back to the House of Lords for what we know as ping-pong. This is where the Commons say we don't like it, the Lords say, oh yes we do, the Commons say we don't like it, the Lords may say, oh yes you should, the Commons will say we don't like it, and the Lords will say, well okay then. Yep. That's what happens. The Lords do have the power to stop a bill becoming law for that session of Parliament. It's got then to be introduced into the next session of Parliament. A year has to go between its first introduction in the House of Commons and its second, third reading in the House of Commons. So if the Lords actually insisted, it would kill the bill. But the Lords are not going to insist. My theory about this is that the principal opposition party has hopes that it will become the government, And were it to become the government, it wouldn't like what would then become the opposition to do the same to them. That's politics. I'm not a politician, I am a lawyer. Well, I very much hope that the European Convention does have a future in the UK, but this drip erosion of its rights is very troubling. And it's part of a wider tendency to disregard the UK's obligations in international law in the context of asylum and immigration, while loudly trumpeting the importance of the rules-based international order in other contexts, such as Ukraine, Gaza, and the Red Sea. And we might add to this selective disregard of international obligations, a willingness among some in government, not all, unjustly to pour scorn on lawyers and even judges who are only doing their job. I cannot resist recalling that on the 18th of July last year, Prime Minister Boris Johnson moved a motion in the House of Commons that this House has confidence in Her Majesty's government. This is not a usual thing, it's usually the other way around. And then he listed his government's achievements. And as part of this, he declared that, quote, "With grim determination, we saw off Brenda Hale and we got Brexit done." That's a pretty jaw-dropping thing, isn't it, for a British Prime Minister to say? And all because Brenda Hale happened to chair a unanimous decision of the Supreme Court of the United Kingdom that what Boris Johnson had advised Her Majesty to do in shutting down Parliament for 5 vital weeks in the run-up to what would otherwise have been Brexit Day was unlawful. So I am even more grateful that this great university has seen fit to ignore Boris Johnson and present me with this accolade. Thank you so much.